business debt-line and national debt-line now for actually 9 years now, 9 years in May. So today I'll be delivering a webinar on private parking tickets, as I realised there wasn't really an awful lot of information there. So that's what we'll be looking at today.
Perfect, thank you. Like I said, we're just, before we kick off, the webinar is being recorded, so you can watch it at a later date. We will also be sending the slides around also after the webinar, so don't worry if you don't keep up. We've got an hour time now to fit everything in, which I think should be enough. And if you've got questions at any time, just pop it in the chat box, and then I'll work with Mark to get those questions answered. Thanks, Mark.
Brilliant, no problem. Okay, so today we're going to be looking at an overview of private parking tickets. So today we're going to cover what is a private parking ticket, who's responsible, how to appeal, potential court action, and the Government Parking Code of Practice Bill, which we'll talk a little bit about as well. So, private parking tickets. A private parking ticket is sometimes called a parking charge notice. This is issued when a vehicle is parked on privately owned property where no consent or permission has been given, or the conditions allowing the vehicle to park there have been breached. So it's not a penalty charge notice, or a PCN as they're sometimes called. That's issued by the local authority, breaching conditions on council-owned land. So we're not going to go into detail today about council-issued penalty charge notices, or PCNs, in this webinar, but briefly, the main factors to remember when dealing with PCNs, penalty charge notices, are that it's for parking on council-owned property. You'll usually either get a notice on your dashboard, or it's sent through the post. You'll get a discount if it's paid early, or a penalty if it's paid late. You can appeal to an independent adjudicator, and if successful, the process will revert back to its initial stage. So we're talking about private parking tickets. So what type of land is private? Types of private land include hospitals, restaurants, supermarket car parks, private car parks in the city centres, so the ones that aren't council operated, and private roads as well. So there are many different ways that you can get a ticket. So you might get a ticket for not paying for the allotted time. So for example, you might have to pay £1.20 for an hour's parking, but you only have £1 change. Or you might pay for an hour's parking and stay for 90 minutes, for example. It could be if the incorrect registration is noted. So this could be where you drive two different vehicles regularly and maybe put your vehicle registration for the other vehicle in by mistake. Or sometimes you might get a digit wrong when typing your own vehicle registration on the screen. You could also get a ticket for overstaying the free parking. A lot of supermarkets will allow 2 hours for their customers. So any more, and the company might feel that you're parking in their supermarket, but you're shopping elsewhere, and they might charge you for being on their land. It could also be for missing or incorrectly displayed tickets. So in some cases, you might get two different slips when you've paid for parking. So where I shop occasionally, you get the ticket that is your actual ticket, and then you get a coupon to scan as well, which will give you the money off. So in some cases, if you took the wrong ticket with you, you then might come back to your vehicle and get an actual parking ticket for that. Or if it's not displayed correctly anyway, so either it fell off the dashboard or it was difficult to spot. So these are different ways that you could get a private parking ticket. And now it boils down to who's responsible. So the driver's going to be responsible in most cases. However, if the company can't find details of the driver, and the company is registered as a member of either the British Parking Association or the International Parking Community, they can ask the DVLA to provide the registered keeper's information. And usually companies will have to pay a fee per request, or they might have a license allowing them to do an amount of requests, either a month or a year, however their license works. It's unlikely that your client is going to receive a ticket through the post for a non-member's car park. If you get a letter through the post for a non-member, you should report it to Action Fraud as soon as possible. So there are basically two trade associations. You've got the British Parking Association, and their members include NCP, Parking Eye, organisations such as East Midlands Trains. The second company is the International Parking Community, and their members include UKCPS, Manchester Airport Group, Metro Park. You can get a list of all the different companies that are members of these actually on their own website, so you can check it yourself. There seemed to be a lot of confusion in recent years about whether or not a private ticket was illegal or not. It was commonplace, and still is in some circles, to ignore the ticket, and things have moved on quite a bit since then. So the law states that when a driver enters into a private car park, they enter a contract with the landowner, and they should comply with the terms and conditions of the contract at all times. And if this is breached, then the driver might be liable to pay charges. In England and Wales, the Protection of Freedoms Act 2012 sets out rules about how that contract is applied and what charges can be considered reasonable. The recommended maximum for a private parking charge in England and Wales is £100. So it's not technically the same in Scotland. There's no similar act. However, the law of contracts still applies, and so in practice the outcomes are very similar, including the financial penalties, which we'll get onto a little bit more in a moment. So the contract should be clearly displayed throughout the car park, particularly at the entrance, and this will detail the conditions of the stay in the car park plus the penalties for the breach of the contract at that point. So it's all really a matter of timing. Drivers should be allowed a sufficient amount of time to park and read any signs so that they make an informed decision as to whether or not to remain on the site. There isn't a set limit for what's deemed sufficient. However, drivers also must be allowed a minimum period of 10 minutes to leave a site after a prepaid or permitted period of parking is expired. So if, let's say, if it was 2 hours parking, they wouldn't say after 2 hours and 1 minute you should leave. They've given you a 10-minute grace period. So the government placed this in their act. The International Parking Community and the British Parking Association have put this in their documentation as well. So you could argue that that 10 minutes might be considered sufficient to read the signs and make an informed decision, although this hasn't been put in practice as yet. So can they clamp on private property? Years ago, there were many instances of people's vehicles being clamped and having to sometimes pay extortionate release fees. So the Protection of Freedoms Act set out to change this, and by providing a formal procedure, they also made clamping of vehicles unlawful in all but some scenarios. So a vehicle can be clamped if it's parked at airport car parks, although if you notice earlier, some car parks have been outsourced to private parking companies, so the rules might not apply in that instance. Some railway station car parks, some ports and harbours. So these are primarily places where a different act will have preceded the Protection of Freedoms Act. It's a criminal offence to immobilise a vehicle by clamp or any other means without lawful authority. And it's a criminal offence to interfere or try and remove a clamp placed on a vehicle by an authorised person. So if there's an instance where a vehicle is being clamped without lawful authority, you should be calling the police on the non-emergency number 101, and then they'll be able to get in touch with somebody who will be able to remove the clamp lawfully. However, if you remove the clamp yourselves, then again, you're potentially at risk of prosecution there. So ultimately, clamping is now almost a thing of the past. Obviously, there are private parking tickets now where the penalties come. And what we're going to talk about now is appealing these realistically.
Thanks, Mark. I was just going to just jump in. We haven't had any questions through yet, but just want to open the door just in case anyone has a query about what Mark's just covered there.
Okay, brilliant.
And obviously give you a little break as well. So if anyone does have a question, either you can raise your hand and I can unmute you if you've called in on the phone, or if you use the chat box, send it through. Like I say, if there's not any questions now, you can always come back to it later, but just give about 20 seconds more and see if any questions come in.
No, okay.
Okay, no, yeah, I say continue on. Just like, if you do think of a question at any time, just put it in there. We can cover it at the end of each section.
Yeah, please do. Brilliant.
Thanks, Mark.
Okay, so we're going to talk about the procedure now. So, in cases where a vehicle is alleged to have breached the contract of the private land, the company should follow their internal procedure. Companies who are members of the IPC or the BPA will have access to the DVLA systems. So they should send a letter, and they should provide information of the alleged offence, so details of the vehicle, the date, the time, location of the offence, and why they believe that contract has been breached. They should provide details of how to pay, with a possible discount if paid early. They should allow time to either pay or appeal directly with that company in the first instance, so directly to, let's say, Parking Guy for argument's sake. They should provide details of the appeals procedure with their regulatory body if the appeal is rejected. So here we've got a sample letter from Parking Guy, and you can see that they've attached a photograph of the alleged offence. You see there it states the details of the car park, how long the person was in the car park for, their arrival time and departure time, and they've used pictures there illustrating the vehicle. In the blurb there, it talks about the discount rate and the details of the breach that they feel has occurred. And in the bottom of the letter, at the very bottom, it talks about further information, including how to pay. So that's the last sentence. How to pay, the right to appeal, etc., can be found on the reverse of this notice. And about 3 paragraphs up from that, it states that you are warned that if after 29 days from the date given, the parking charge has not been paid in full, they have the right to recover any unpaid part of the parking charge from you. That's basically saying that they're going to look at further action if it's not paid. So that's the standard format that you'll receive from these type of organisations, providing as much information as possible. And as I said, at the end, it will talk about how to appeal. So appealing a private ticket, as the Protection of Freedoms Act states how the contract is applied, there are going to be very specific grounds to appeal. And so the potential main ones are going to be if the correct ticket was displayed. So again, it's really important to make sure that this can be provided if requested. If the charge has already been paid, so again, any evidence of when the payment was made, either by a receipt, a bank statement, something like that. If you were not the owner of the vehicle at the time, perhaps it was sold on and the DVLA haven't amended their records in time, and you can chase that up and provide that information. Or if the vehicle was stolen and parked without consent. So again, realistically, you'd need proof of this, so a police report or a crime reference number, something like that. Or if there are poorly located or no proper signs. So basically, if the company hasn't fulfilled their part of the contract, and again, evidence of the scene would be necessary here. So pictures of the signs, the location to the entrance, are the signs illegible? Are they broken, or is there other reasons as to why? Potentially is there trees or something blocking the signs? What is the issue with the actual site in question? And again, provide photographic evidence of that. The details of where to send the appeal to and the timescales to do this should be clearly noted on the rear of the ticket, and copies of the appeal should be kept in all instances. If the appeal is accepted, the ticket should be withdrawn, no further requests for payment should be made, and again, keep a copy of any letters sent or received if there is one. So, if you appeal in time and the appeal is rejected, you should receive confirmation of the company's appeals body and an individual reference number to use, and this is important. You'll need that when taking it to the relevant authorisation body. There's a time limit to escalate this further, and if you're later in applying, there may be a fee to pay, or in some cases they may say that you're out of time, and unfortunately these are very strict. So time limits, for the members of British Parking Association, you have 28 days from the rejection to escalate it to the Parking on Private Land Appeals, which is POPLA. And for the members of the IPC, You only have 21 days to escalate it to the Independent Appeals Service. The IAS may consider appeals after 21 days, but there is a non-refundable fee of £15, which is for their non-standard appeal. So there's the details of the websites as to how to appeal, and you'll need that rejection letter from either the BPA or the IPC before you can escalate it further. So both Poplar and the IAS have stated that they may not accept mitigating factors such as emergencies, health issues, things like that. They're basically to check whether or not the charge is lawful in their opinion. So any mitigating factors should be stated in the initial appeal stage to the company in question, along with any documentary evidence. It's unclear whether or not in practice companies will accept certain mitigating factors over others, or whether or not, because the trade association may not accept these factors, the companies dismiss it out of hand as general practice. So if there are rejections to an appeal, there's little left from the client's perspective if they have followed the correct procedure and the ticket still stands. Basically goes to collection stage. So as the debt is a civil matter, if the ticket is unpaid following appeal being rejected, or if no appeal was made, the next step is usually debt collection agencies. Most debt collection agencies don't have the authority to discuss a dispute. They're basically just there to chase the money. Further fees may be added at this stage. So usual practice will apply. They may send letters requesting payment, threats of court. Obviously they don't have any special powers. So here, realistically, if we feel that the company has acted unfairly, there have been instances where they have been treated unfairly. So as private parking tickets are still relatively new, it's important to raise any issues as much as possible, ultimately. So if the company hasn't followed the correct procedure, there might have been a delay in sending the rejection, meaning an appeal might be out of time, or any documentation may have been sent to an incorrect address. You need to complain, basically. So in respect of this, you complain. They're not going to look at whether or not the ticket is valid at this point, but they can sanction their members if they feel that they've acted unfairly. So in some cases, a company's membership could be revoked, meaning that they would no longer have access to the DVLA records. That would make things a lot more difficult for them. So to complain, you do it in writing to the private company, copy in the trade association and any debt collection agency if they're acting for the company at this point. Explain what you're unhappy with, what you want them to do about it, request full details of their internal complaints procedure, and follow that to the letter. You can also consider contacting the Citizens Advice Consumer Helpline, who then can help report the matter to trading standards. And the more information that's gathered at this stage, the better it's going to be for clients going forward. However, in some cases the ticket may still have to be paid to avoid court, and it's realistically at that point going to then depend on how a client's feeling about the case, whether or not they feel it should be challenged, and that's going to dictate their next steps, realistically. So if the debt collection agency or the organisation hasn't received any payment, then they may decide to look at court proceedings, which we'll get to in a minute. So have we got any, have we got any questions at all?
Yeah, there's been a few, 5 or 6 questions. First one from Gillian. Can you see it, or do you want me to read that one to you?
I can scroll up, just give me
a moment. Yeah. It's about GDPR, that's the first one, and then I guess we can just work our way down, if you like.
Yeah. Do you foresee GDPR as having an effect on the company's ability to get owner details from the DVLA? If if I'm being honest, I'm not 100% sure how that would have an impact on them. Assuming that the DVLA and the company have been able to arrange something, then I can still see these companies being able to continue their practices ultimately. I'm not sure if anybody else has heard anything to the contrary.
Okay, thanks, Mark. I think then the Connor's question just below that.
Yeah, if a vehicle is illegally clamped and no authorised person to release it is available, does that mean whoever has illegally clamped it is liable for any possible recovery or towing costs? Or is that a court case? Yeah, I would argue that that would be a court case in that respect. Again, if the police are able to remove the clamp, again, the police may be able to remove that using force, whereas obviously if a person was to do that, again, they could be winding themselves up for, you know, potential prosecution claims against them.
Thanks, Mark. And then the question below that, I think, was related to something that you mentioned.
He's saying that the law doesn't require the landowner to affix the notice on the car where there is no automated camera. I mean, in respect of that, I think I'm not 100% sure on the actual contract here, but my understanding would be that if the organisation is a membership, has a membership rather, or either the BPA or the IPC, and they can use DVLA technology, provided that there wasn't an opportunity for them to affix the actual notice to the windscreen, they could argue that they're allowed to go through the procedure of sending it through the post. So similar to how council issue penalty charge notices work, if they haven't had the chance reasonably to be able to put it on the windscreen, they can send it through the post. My understanding would be similar rules would apply at that point.
Perfect. Gillian just had she had a success appealing a ticket. And then the next question
fantastic.
The next question was from Chris. Will a court claim consider mitigation circumstances?
That would be ultimately a question for the courts. I think the difficult part that you're going to have, and we'll talk about it a little bit more in a moment as well, is costs involved realistically, and you know, whether or not a person is going to take it to court, knowing that if they're unsuccessful, the debt's going to be very high in relation to the original penalty. As we mentioned before, you know, £100 isn't deemed excessive if you're looking at kind of from the claimant's perspective, the parking company, if they say, well, you know, it's £85, that's less than the £100. If they go through court, and if for whatever reason the court feel that the parking charge is something that should have been applied, it won't just be £85 at that point, there'll be extra costs. No, it's a good point. I understand in relation to their disability that yes, they may have to, or they may have been in a position where, yeah, the time that they're actually there for may be longer. In respect of that, the mitigating factors are definitely something to put to the original company. As I said before, we don't really have an awful lot of information about how the companies like Parking Guy, etc., are looking at these mitigating factors, but my understanding is that the Poplar and the IAS, they're there realistically to apply the law of the contract. However, in relation to the court, again, that may be the avenue that they may look at something differently. However, as I said, there is that risk there of not just the costs of the original ticket, but also any court costs as well, which again, you know, is something that the court are going to decide what is a fair and reasonable cost to be added to the debt, depending on if it got to that stage.
Perfect. Thanks, Mark. I think you again are just conscious of time, but I know we've got a bit of time left. But yeah.
No, I appreciate it's very difficult for some people in relation to these strict time frames. So the 10-minute grace period, the 28 days response, and then the issues with the appeals process. And this is realistically what this webinar is designed to do, is to kind of understand these things a little bit, promote best practice, and then we'll talk about things that the government are looking at as well, and hopefully that'll mean good news for everybody in the future as well.
Thank you.
Okay. So, sorry, I meant to mention here. So, as we said, debt collection agency, they can issue court proceedings or a solicitor or the actual business themselves. And in England and Wales, from October 2017, they must follow the pre-action protocol. So they shouldn't just issue a claim form after no contact or after the defendant, the respondent saying that they're not going to pay it. They should follow the pre-action protocol. So this webinar is basically going to assume that you're familiar with the pre-action protocol. WiserAdviser has got a lot of information on the pre-action protocol, as well as its own webinar on the subject there as well. So, as I mentioned, any court proceedings are likely to increase costs, and the client's basically going to need to weigh up the consequences and the implications, especially if they don't have a strong argument. So at the moment, bear in mind that the debt won't show up on a person's credit reference file because it's just an amount of money that is alleged to be owed rather. This would obviously change if a person receives a county court judgment that isn't paid within a calendar month of being awarded. So both England and Wales and Scotland have seen very high profile cases go in the parking company's favour. So Beavis versus Parking Eye and Vehicle Control Services versus Mackie both saw the individual unsuccessful in the court. If challenging a ticket in the court, legal advice must be sought due to potentially large costs. So in England, there was a really important case that was heard through the court. This became a landmark ruling and put to bed a lot of people's arguments about the amount being pursued being inflated when put against the company's actual losses, and that was Beavis versus Parking Guy. So Mr. Beavis overstayed nearly an hour in a parking area that was free for 2 hours. He argued that the £85 charge was unfair and disproportionate. He took the case to the Supreme Court and was unsuccessful. Unfortunately, we don't have any confirmation of the amount of costs that were awarded. It's reported that the magazine publication Which, they helped with Mr. Beavis' fees. He also set up a crowdfunding page which amassed over £7,500 in 24 hours, and the lawyers representing Parking Guy agreed to lower their costs in order to see the case go to the Supreme Court. So they all wanted this to go as high as it could realistically. It was a great outcome for Parking Guy, unfortunately, and it basically meant the floodgates opened for similar cases that had been treading water up until that time. So as an advisor, I had, after this case ruling, I had a few claim forms from clients that I was speaking to come out kind of very shortly after this case because they felt that it was a similar argument. And at that point then, because of the fact that Beavis versus Parking Guy went in Parking Guy's favour, it was very difficult at that point then to argue that these penalties shouldn't be paid, unfortunately. And in Scotland, we have Vehicle Control Services versus Mackie. So Ms. Mackie parked in a private parking area which required permits for residents. So it was a residential area with private parking. She didn't have the required permit, and she ignored signs requiring vehicles parked on the property to have one. She refused to pay more than 200 tickets and didn't seek to obtain a permit where one could have been issued. And through the Dundee courts, she was ordered to pay £24,500. So even though there's no act of Parliament, such as the Protection of Freedoms Act, the law was great for a long time, and this case in 2017 saw a bit more clarity on the law in Scotland. So where Beavis versus Parking Eye established the level of reasonable costs that could be incurred from a breach of contract, Vehicle Control Services versus Mackie saw that the principles would be considered the same, even though in Scotland there's no Act of Parliament to support it. These cases are very well known by parking companies, and their reasons to advise a client not to ignore the ticket. There are still some issues surrounding the implementation of the court process, and so the government set up, excuse me, they send out requests basically for opinions on creditors taking court action where they may have had reason to believe that the defendant no longer lived at the address. So that can be from all different types of debts, from old fuel arrears, where obviously the person's left the premises, to old catalogue debts, old credit cards and parking tickets. And for private parking tickets, this is a concern, as many judgments are going to be under £255 if they're unchallenged. And so a set aside, even if technically the right way to deal with a claim, may not be cost effective. Again, it's going to be assumed here that you understand what a term set aside means, but in a nutshell, it's basically a way of rewinding a judgment to a point before court action was taken, thus taking the debt back to its original state, its original cost. It's primarily aimed as a tool for disputing a debt where a formal defence was not filed within timescales. And the cost, £255 as we mentioned, which is usually higher than the county court judgment, and so may not be appropriate in cases due to the further cost implications if you're unsuccessful. And again, it's really important that legal advice sought if considering going down that avenue. Obviously, if you're on a very low income, you would get help towards the £255, but again, depending on whether or not you're successful or not at court, again, if you're unsuccessful, there might be costs involved anyway, even if you didn't have to pay the £255 initial fee. So bear in mind, it's going to be something where if a county court judgment's on a person's credit reference file, because it hasn't been paid within that calendar month, is a defendant then going to want to apply for a set-aside purely to remove it on the basis that it may cost them more than the original judgment, ultimately. So, following the introduction of the Protections of Freedoms Act, drivers have felt that there's not a lot of assistance and support, and drivers are looking for change, which brings us on to the Government Parking Code of Practice Bill. It appears that the government is looking into a Code of Practice Bill. This will hopefully make things better for our clients and make it clearer for everyone. MP Sir Greg Knight's Parking Code of Practice Bill had its second reading in the House of Commons in February 2018, and its aim is to tackle what they class as rogue parking operators. And under the legislation, the government will issue a bill to the parking sector to fund the code. So a summary of the bill states it's a bill to make a provision for and in connection with a code of practice containing guidance about the operation and management of private parking facilities and for connected purposes. It's hoped that this will bring some much needed reform to the private parking sector to bring the process in line with the council issue penalty charge notices, as we mentioned before. And Steve Gooding, director of the RAC Foundation, said that the move would bring some much needed regulatory rigour to the world of private parking. So again, it's just a case of watching this space here at the moment. Hopefully we'll be getting some good news in relation to this, and hopefully the rules will seem a little bit more balanced for drivers. So in summary, the driver is responsible for the charge. The owner usually receives the ticket. Clamping is illegal in most areas, and it's important not to remove your clamp yourself for failure of prosecution, risk of prosecution. There's a minimum 10-minute grace period. This is in accordance with the Protection of Freedoms Act. £100 is not deemed excessive, and this has been tested in court. So you need to make sure and check if they're a member of either the BPA or the IPC, and follow the strict timescales to appeal. Legal advice is needed if you're going to challenge in court due to the costs potentially incurred, and it's really important not to ignore the ticket. Thanks for attending this webinar. So have we got any more questions?
Yeah, thanks Mark, that's really useful. We're slightly ahead of time, which is a good thing. I think we'll just hang about for a few more minutes and see if anyone has any questions.
I think we've got a couple.
Yeah, a few have come in, more statements, but you can read them out if you like.
Yeah, parking I failed to respond to my informal appeal. Took it to Poplar and Parking I chose not to challenge. It's annoying that parking companies do, in my experience, completely ignore the reasons for the informal appeal. simply restate their original reasons. I've read in discussions forums that this isn't uncommon. Yeah, I think you're quite right. It's obviously good that you're taking it further and challenging it. And again, if Poplar have then agreed because Parking Guy haven't done anything, then that's obviously a win for yourself. It's very successful. However, yeah, I appreciate not everybody who receives these and makes the first challenge are then going to escalate it to Poplar when perhaps that they should. Yeah, I think that in these type of cases, again, as I said before, you know, complaints, if you feel that this is a pattern, the more people that report this through the Citizens Advice Consumer Helpline, the more information goes to trading standards. When this Code of Practice bill is put into place, when they start asking organisations for this anecdotal information or evidence, then again, this is only going to make the kind of the case for this more robust, basically. So yeah, I think it's great what you're doing there. Just keep it up, and you know, as I said, the more information that gets sent, the more information that's logged, the better for everybody, basically.
The next couple ones were more statements. There are a few questions coming in.
Okay.
Chris, it's the first one.
Yeah.
Not a question, maybe.
As
Yeah.
a general rule, don't like advising on private parking tickets because clients feel so passionately. Yeah, it's very emotive for them, and it's one of those things. Ultimately, are they going to win? And it's where, again, a lot of the time, because we're not legally trained, it's really important for them to get that legal opinion. So if the driver didn't receive notice to owner and the landowner refused to consider out-of-time appeal, can a court claim for unpaid parking charge be challenged on this ground? So again, it's going to be legal advice at that point, realistically, because there's one issue of whether or not it was received in time. The second issue is the appeal valid? You know, is there only appeal that they didn't receive it? Again, it's going to be legal opinions needed to see, you know, in court, what would be the potential outcome of that. Jeremy Corbyn reckons he will abolish charges in NHS hospitals, usually run by Parking Eye. Will he actually be able to do this? That I'm not sure. It'd be interesting to find out.
I think the point Carol made below is, yeah, in Wales, I think all NHS hospitals do have free parking.
Oh wow, okay.
And
so yeah,
yeah,
that's very interesting.
See if there's any more questions, but if not, we can wrap it up. There's this one.
Yeah, quite right. So it would go through normal court procedures. As I said, realistically, the pre-action protocol should be considered first, as it's a business to a person. So they should receive a form to fill in with information whether or not they understand what's going on, whether or not they admit that they owe the debt, or if they need more time, or if they need to get advice. And then if any communication breaks down, a claim form would be issued, and they would have 14 days to respond to that claim form, either by accepting or disputing or asking for further time.
Perfect. I guess just to recap again, we will be sending this recording out to those who have attended, and also the slides. Comment from Andrew saying his first webinar, thoroughly enjoyed it. Thank you.
I'm glad to hear that. Thank you.
And then I think one more question from me, and then let's do that one. And
yeah.
then
If the pre-action protocol is not followed, then what would the court decide if a money claim is made? So we do have a webinar on pre-action protocol, and I do believe we do have some information.
Yeah, I can send that link out with this one if that's useful.
Oh, perfect. Yeah, that would be brilliant.
Yeah.
So with that, unfortunately, while not following the pre-action protocol may not have an impact on the actual claim, it may have an impact on sanctions or other penalties that the claimant might have to pay if they've acted inappropriately. Again, it's only been going since October of last year, so it's all really early on at the moment. But yeah, I think the more information we find about that, the better going forward.
Just another question around you. I think we'll try and get the slides out by the end of the week, usually, with the recording. And normally we send out a feedback form too, so yeah, by Friday hopefully we can send everything out. But yeah, okay, thank you. Well, thanks for your time, Mark. It's been great today.
Anytime. Thanks again. Take care, everyone.
For joining. Cheers. Thanks, guys. Bye.
Bye-bye.